Thank you, Mr. President. Good afternoon, colleagues. I appreciate your patience, and I know this is a bill that has received a lot of vetting, a lot of consideration. A lot of time has gone into the issues that we are talking about here today, and I want to begin by thanking Governor Kemp for leading on this issue and his work on something that is an incredibly important measure for our state. I want to thank our president, our Lieutenant Governor Jones, who has done a great job in being supportive of this measure all along the way. And I also want to thank Speaker Burns, who came out early on and said he recognized the necessity that we get something done in Georgia to help hardworking Georgians, to help us simply rebalance our civil justice system. I'm going to try to be brief, but I do want to go over and tell you about the substitute language that's before you today, which is very largely similar to the bill that passed out of this body just a few weeks ago with bipartisan support. I want to highlight the efforts of both the House and the Senate committees, the business community, and those that came and shared their testimony with the committees both on the Senate and the House side. The governor, Commissioner John King, and legislative leaders, many of whom are in this chamber today, have spent the past 2 years collecting data and participating in roundtable discussions with businesses, healthcare systems, and everyday Georgians to talk about what the problem was. You know, many of us had hoped that we might be working on some legislation, specific legislation, in 2024 last year. But our governor is a very, very thoughtful governor, and you'll remember that we passed HB 1114, which was the tort data collection bill, so that we could find out more information that was not readily available from insurance companies that would inform what would ultimately go into the bill that you have before you. Through that entire process, along with the roundtable discussions with people around the state that the governor held, we learned a lot about what needs to be changed and what needs to be done. Not only that, but even after the Senate Bill 68 and Senate Bill 69 were filed, as the governor said in his State of the State address, he said that we were going to continue to have meaningful discussions. And we did. And you'll remember that after that initial filing of Senate Bill 68, there was a substantial revisions after working with various stakeholders, primarily the plaintiffs' bar and the GTLA, that produced the substitute that was presented to the Senate Judiciary Subcommittee. And then that was even further modified by what you voted on when Senate Bill left here from the Senate floor with regard to an amendment that substantially revised one of the portions involving phantom damages. After the bill passed out, as I've alluded to, all folks involved with this process, with the governor's office leading on this, have continued to meet and listen to the concerns. And then when it moved on to the House, it was exposed to over 15 hours of testimony and feedback from the public, committee members, and a broad spectrum of stakeholders. Yesterday, Senate Bill 68 passed the House as amended with bipartisan support, and I'm grateful to those leaders in the House that presented the bill, carried the bill, and also worked on their specially formed subcommittee from the Rules Committee to hear this measure. The substitute before you today incorporates input from the Georgia Trial Lawyers Association, victims advocates, and various plaintiffs' lawyers around the state. This substitute is a result of dozens and dozens and dozens of hours spent diligently working with the House and the Senate and the governor's office and stakeholders from all sides. As I said, Governor Kemp said in his State of the State that there would be room for the legislative process to play out, and that is exactly what has happened with input from all sides. But the governor also made it clear in the legislation that it should not and will not be a half measure. And I believe, friends, that this substitute in front of you today strikes that needed balance. The House added clarifying language to guard against any misapplication of the bill's provisions to protect both parties while ensuring open and fair access to the civil justice system. Let me walk you through those changes and briefly tell you what they are. You'll find in Section 1 of the bill, which was the provision dealing with anchoring, and it clarifies that the requirement to argue the monetary value of non-economic damages at the first opportunity for the closing argument means the first closing on the issue of damages, not the first at any point of the trial, but the first on damages. So what does this do? Well, it makes the interaction and interpretation of this section with Section 8 dealing with bifurcation clear that it prevents any misapplication. It also clarifies that the second closing argument that counsel can argue the monetary value of non-economic damages again, as long as the argument was made during the first closing. This prevents either party from sandbagging the other by delaying and not talking about what the anticipated damages are or what's going to be requested. And finally, it clarifies that the advocates can still ask questions during voir dire about jurors' willingness to simply award damages. Section 2 involves motion to dismiss. And I know this stuff is thick, lawyerly bill stuff, but for those of you that, and I know many of you educated yourselves on the details of this, and I wanted you to understand the changes that the House made, and quite frankly, not only why I support them, but why they made the bill better. Section 2 highlights that if a court fails to rule on motions in a timely manner, then a writ of mandamus may be issued and be used to keep the courts accountable. This is important because it puts accountability where it should be, and that's on the court, to keep the case moving forward. There's only 3 more sections. The third is Section 3 involving voluntary dismissal, and it makes the clock for the voluntary dismissal start upon the filing of the answer, regardless of whether a motion for summary judgment is filed. Well, why is that important? The catch, if you will, that was made by the House in looking at the language was good because it closed a potential loophole that defendants might take advantage of that would unduly and could have been used to game the system to prevent the plaintiffs in having that portion of discovery period that we agreed ought to be a part of that. Section 5, dealing with seatbelt evidence. This preserves the trial court's inherent discretion to determine whether and for what purpose evidence of seatbelt use should be admitted. Seatbelt use still must be relevant and non-prejudicial. 2 basic standards for any evidence, and of course we know the judge is the gatekeeper, the referee, if you will, of what goes to the jury, and he or she as a judge still operate and do that function. Lastly, Section 6 involving premises. It increases the carve-out for sex trafficking victims, and it excludes any claim relating to a violation of 16-546, which is the criminal provision dealing with sex trafficking. So what does this mean? It means that Section 6 provides valuable protection not only for businesses trying to do the right thing and needing to know and understand what that means, but also no protection for businesses who fail to act against human trafficking that occurs on their watch. It also places a clear limit on the application of Section 6 so that the other claims, such as those based on the failure to supervise employees and negligent hiring, which was really most of what we heard the senator from the 44th just complain about with her amendment, that somehow this bill as written was going to deny those claims. I would encourage you to do one thing. Read the bill. What she represented to you is not in this bill, not in word, not in ink, not in intent, and not in a desired policy. It ensures that Section 6, as interpreted, is intended to prevent businesses from liability, to protect businesses from liability due to factors outside of their control, while ensuring that businesses still face liability and face fault and face responsibility for what is under their control. The last section deals with bifurcation. Y'all remember we talked about that. That's where the parties can elect to have the trial split into simple 2 phases, same trial, same judge, same parties, same courthouse, just 2 phases for efficiency purposes. The changes that the House made allows the court to reject a demand for bifurcation in 2 types of cases. One, small cases in under $150,000. The court can say, no, this is too small of a case. We're going to not allow bifurcation. Second, and by the way, that's not some crazy thought because the same threshold is what North Carolina uses for their bifurcation statute. Second, where the plaintiff is a victim of sex offenses and the potential additional testimony would cause additional emotional trauma for that witness in testifying about such horrific acts that they have endured, regardless of what's at stake, the courts have the discretion to prioritize the emotional well-being of the victims of these horrific offenses so that they will not have to testify twice if the court so finds. These changes preserve bifurcation as a tool for both parties to ask for and use to give us those efficiencies, while ensuring that the procedure does not clog up the court system or stop a victim of a sex crime from seeking justice through the civil justice system. You know, Georgians from all across the state have come to us asking for a more fair and balanced civil justice system. Through this process, we have all heard we've heard from hospitals, we've heard from the medical care, the communities that take care of us when we're sick. We've heard from the business owners that give our families jobs. We've heard from everyday Georgians who are struggling to make ends meet because of the litigation tax that's on our families now, and those that are scared when they pick up the letter opener when they get their next notice from the insurance company of where the premiums have skyrocketed to. We need to do something about this. Senate Bill 68 proposes and does just that. I know we've voted down the amendment that was offered by the senator from the 44th. And I'm not going to take your time with the hour of the day to refute all that was said. But I will tell you that in my 11 years of being a legislator under this gold dome, this may be the most misrepresented piece of legislation that I've ever seen. You'll note what was not told to you during the presentation of the amendment was any specific reference to a provision of the bill that did what she said she feared would happen. And the reason is the bill doesn't do what was represented to you. And the reason that the language protecting victims of sex crimes was added was raised only as a question on the Senate side of could it possibly impair the bills that we passed 2 years ago to specifically give rights to those that have been sex trafficked and human trafficked. And so the language is added to make absolutely certain that those provisions of 51-156 were in no way impinged by this bill. But I'll give you one other thing to think about. You just heard the description of what this bill supposedly does. Does anybody in this chamber or anybody within the sound of my voice think that Governor Brian Kemp would propose a bill or a piece of legislation that would in any way decrease what the victims of sex trafficking and human trafficking in this state had available to them? If you have any thought like that, let me remind you of who he's married to. Our wonderful First Lady, Marty Kemp, who has for her entire tenure as our First Lady championed and done all she could for the victims of human trafficking and sex victims. In case you're wondering, how about Senate Bill 158 in 2019, the Anti-Human Trafficking Protection Response Act? How about Senate Bill 435 in 2020, the Survivors First Act? These are the things that Marty Kemp and Brian Kemp have championed for the women of this state. House Bill 823 in 2020, House Bill 911 in 2020, Senate Bill 33 that so many of us were proud to vote for in 2021, Senate Bill 34 in 2021, Senate Bill 461 in 22, Senate Bill 42 in 23, Senate Bill 370 in 24. And our First Lady continues to work for the victims of sex trafficking this year with Senate Bill 42, which is pending in our legislature for approval. So yeah, I do bristle a little bit. It's a bit offensive to characterize a piece of legislation like this in the way that this has been, knowing that this is Governor Kemp's priority for his legislative session this year. I'll leave you with one other comment. We had folks come and testify on the House side and on the Senate side. And it was done so in a way as if to suggest that if this bill passes, they'll have no causes of action to sue anybody for what they've endured. And that's not true, and I won't take your time with it, but on the House side, we went and found the complaint of someone who came and unfortunately had been misled, severely misled into believing that this bill would have restricted the kind of compensation she already got. And we went and demonstrated that because all of the other causes of actions in Georgia law are remain untouched that folks have available to them. But I thought what was maybe somewhat rather telling is one of the members of the House Special Committee, a lawyer, who would have had us believe with the nature of her questions and her vote yesterday that this bill was just going to strip all the rights of Georgia for the victims of sex trafficking. But let me read to you from a complaint that was filed in the United States Federal Court for the Southern District of Georgia. Here's a copy of it. Lawyers have to sign pleadings with a requirement of candor to the court. Fortunately, Georgia has followed the federal government's lead in recognizing that actors other than actual traffickers and Johns were participating in, promoting, facilitating, and benefiting from the selling of sex and sex trafficking through the passage of SB 33. With the passing of SB 33, now codified as OCGA 51-156, Georgia now joins those states in providing trafficking victims the option to pursue civil suits. That's what's in the pleading. That's not the narrative that you're hearing, because that's not what they want, because they want this measure to not pass. I've been humbled by the outpouring of support simply for a balanced civil justice system. As the bill sponsors, I've had the distinct privilege to meet so many Georgians across the state who are begging for relief. And through a process, I feel hopeful that something can and will be done today. All those folks came to see us, whether it was the day that we dropped the bill or came from across the state to the various times that the governor held the roundtable discussions, because they were asking you for a vital and urgent support that they sent us into this building to provide, and it's a way that we can give it to them by acting today. Colleagues, I ask your favorable consideration of this very thoughtful approach to simply balancing our civil justice system, and I appreciate your patience. I appreciate all the work that's gone into this from so many people from around the state, and certainly the legislators that have given this consideration. Mr. President, I'm happy to answer any questions, or I'll yield the will.
You have one question, Senator. Senator from the 26th.
Thank you, Mr. President. With Senator Yield.
Yes, sir, I do.
Senator, you talked about sex trafficking, but it's more in that bill than just sex trafficking. Am I right?
Yes, sir. There are 8 sections. One deals with premises liability, but only negligent security. So not all things dealing with premises liability. And then there are the other 7 that deal with the rules of the road, if you will, on how we lawyers and judges manage trials. And yes, sir.
So I'm not a lawyer. The only thing I can do is try to read it and make the best of it. But in your statement, you said y'all met with the Georgia Trial Lawyers Association. What suggestions were made to you all in the discussion of this bill that y'all accepted from the Georgia Trial Lawyers Association?
Senator, there numerous suggestions that came. For example, the initial bill that was filed, there was an objection to one of the sections that was completely removed. The issue on the motion to dismiss timing, which the initial proposal followed and mirrored the federal rules of civil procedure, which meant that the plaintiff had up until the time the defendant files an answer to dismiss their action. They asked for some time to do some limited discovery on to make sure that the jurisdictional and venue and proper party issues were properly addressed, and asked for time. So the time date was moved back from the timing of the answer to the 60-day period that was suggested. The trial lawyers also did not like the initial approach to phantom damages, which is truth in medical billing. And what we see in this proposal that came out of the Senate and was left unchanged by the House because it's a very good compromise is not only does the jury see the rack rate, which was being the policy behind the initial Senate bill was that they would only see the actual amount needed for reimbursement. But we wound up with a landing spot where both numbers go to the jury. That was at the specific request of the trial lawyers and those that engage mostly in plaintiff's work. I can go on and on, Senator. There were a lot of changes, and as I said in my earlier comments, every step along the way from the initial bill that was changed to the sub, that was then changed by the amendment in this body, that was then sent to the House, that was modified by the 7 or 8 different sections that they changed, would be fairly characterized as all those changes were moving in the direction as requested by the plaintiff's bar.
Senator, yield further.
Yes, sir.
Senator, we, and I don't know where you saw it, we had a copy of the Speaker of the House in Florida talking about insurance companies, and that the main one says they lost this, but their subsidiaries made billions of dollars. So where are we when it comes to insurance companies? Because most of the litigations is dealing with insurance companies and what they pay out. Now, isn't it true if you have a claim or you call in to the insurance company, that's what they call an inter-office memo, and they decide what they're going to pay on that particular claim, whether it's high or low, but they're not going but so much. When they do that, and say they set aside $100,000 and they only pay out $50,000, do they in turn tell the insurance department on their claim sheet, well, we paid out $50,000, but they had $100,000 set aside, so the other $50,000 went back to the insurance company? Or do they report to the insurance company that was a $100,000 claim?
Senator, if I understand your question, you're asking about the retention policies and how that data is communicated to the Office of Insurance Commissioner. I really don't know the answer to your question. I would tell you I doubt that insurance companies, but I don't know this, report what their retention levels are on a claim-by-claim basis. I do know and understand that the Office of Insurance Commissioner does evaluate their overall retention policies because they want to make our insurance commissioners, I'm sure other insurance commissioners do as well, they want to make sure that the retention amounts that the carriers have are capable of sustaining the payment that may ultimately be required. Okay. Thank you, Mr. President, and I appreciate everybody's time. I urge your support for this bill, and thank you for your patience.
Recognized Senator from the 53rd.